Oh, what are we doing with this?
I think we started it last time we were here,
Mm-hmm.
and I think we said rest it, and I don't know whether they were gonna.
Oh. So do y'all have the exhibits with the exhibits are with the other court reporter, correct?
Yes, ma'am.
Okay. All righty. So the court found violation of condition number 1 true. All right, is that correct?
Yes, ma'am.
I
My
see.
recollection.
Mhm. All right, we're going to go on the record in 2022 CR. Just one moment before we do that. Counsel, do you have a trial court certification of defendant's rights to appeal? You may have turned it in last time, but it's not in the file. So if you could do that for me.
No. Yes, sir.
For the record, for the state
Hank Wilkins for the state, Your Honor.
defense.
Cornelius Cox for the defendant.
And are you Mr. Balboa?
Yes, ma'am.
All right, the court did have a chance to review the exhibits that were entered in the contested hearing from April 30th. The defendant had pled not true to violation of condition number 1. Evidence was presented as it relates to violation of condition number 1, and that was states exhibits 1, 2, 3, 4, 5. And the court found violation of condition number 1 true. And we're now here for sentencing. State, what are you requesting?
Your Honor, we're asking for 15 years in the prison based on the underlying is a second-degree felony, Your Honor. It's a drug case, but I know you've seen the court summary. The defendant had opportunities on probation, and he got something for it in exchange for his plea, right? So in exchange for pleading to deferred, he's looking at the full range here. But he didn't take advantage of that opportunity while he's on deferred, Your Honor. He wasn't reporting. Didn't do a whole lot when he was on that community supervision, Your Honor. And then he did assault that officer. I know you heard the testimony, and you saw the video, and you saw the pictures. So that's why we're asking for 15 years, Your Honor.
All right. Defense?
Yeah, if I may, I know the court saw the video. In testimony, I know the court found true, but even the officer, as he testified, indicated that my client was always moving away from him. There was some suggestion that my client would say maybe the aggressor. Now, there may have been some type of resisting, but in terms of actually assaulting the officer, I don't think that was clear on the video. I don't even think by preponderance of the evidence. Both parties, my client was injured. He went to the hospital. I think the officers got some pictures too at the hospital.
All right. I did see on the video your client punched the officer, and it was his first day on the job, I think. The witness who testified, yes, he was brand new.
And I don't think I didn't see it that way. I saw there was some movement, but in terms of a punch, though my client's name is Balboa, I can see that, but the punching part, I think it was more backing up, trying to create distance between him and the officer. And I think on the video, it was indicated that my client was basically just trying to close his house down, and he was going to leave peacefully, but it never came to that. So he got he got hurt too. I mean, some things were done. I just feel that judge on this type of situation, I think 15 years, like the state is asking for, based on the underlying.
If he's revoked, what would you be asking for?
If he was revoked, my first preference would be to continue him on. And basically she just wants work, he wants to provide for his family, and he would absolutely love another opportunity to improve himself. But I think if the court is gonna revoke him and give him a felony record, my suggestion would be 2 years.
All right. So here's the thing, Mr. Balboa.
Yes, ma'am.
You entered a plea bargain agreement,
Yes, ma'am.
and that plea bargain agreement was for punishments to be assessed at 6 years. The state was silent on your application for deferred adjudication, but they were recommending community supervision. And I'm sure I probably told you, if I grant your application for deferred adjudication, you're subject to the full range of punishment.
You did.
All right. And so do you remember my saying that to you?
Yes, ma'am.
All right.
And may I say something?
Well, here's the thing.
Okay, so-
Do you want to be subject to cross-examination? Oh, that means that the state would have a chance to question you. All right. So probation, has he done anything on probation?
I was doing the parenting class. I missed one day and I had to restart it. Just a parenting class.
I don't know. Could you please speak up? I can barely hear you. Could you?
I'm sorry. Yes.
Evaluation, Judge.
All right. She states he's done his TAP evaluation.
We last reported in March of 2023. So I don't have anything that's current as that.
All right. Thank you.
You said,
Well, I was doing the classes, but I missed one.
All right. So here's the thing. If you all whisper and have a conversation, the court reporter is trying to pick it up and put it in the record. So
I would just like to urge that sometimes probation's records, sometimes not as complete. Client indicates that he has taught the parenting class, then when they miss a class, they make them solve it.
mhm. All right. The court is going to find you guilty.
Yes.
Court is going to grant the motion, revoke you. The court is going to sentence you to 7 years. I'm going to give you credit for any time served. And I'll ask for the therapeutic community. Is there anything else?
Nothing.
Nothing for you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, so you have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. I think you know deep down in your heart, I gave you a chance to be on deferred adjudication. And all you had to do was report, do some classes. And if I ordered parenting classes, it's because you had a child. You saw yourself on the video, right? I mean, you saw yourself on the officer's body cam.
Yes, ma'am, but I have film on my own as well, but I'm not gonna.
I'm sorry, what?
Nothing, right? It's irrelevant.
All right, because they were coming to serve a warrant because you have a warrant out this court.
So you said they were there for a welfare check. So,
Yeah, I mean, a welfare check plus, guess what? When they went to go do a welfare check, according to the officer's testimony, they found out that you had a warrant, and that warrant was not reporting for your probation in this case. You understand? So guess what? If you would have been reported in probation, they probably would have never had to do a welfare check. You know why? Because if you would have had an issue with mental health or anything else, you could have told probation, probation would have taken care of it. But at the very least, they would have just been there potentially for a welfare check. But now it spirals to this. You understand? All right, what's happening with this other case?
I'd like to talk to Mr. Cox about it, Judge.
All right. All right, just have a seat in the box.